Good day. Today we are looking at the very important and interesting topic of carriage of goods by sea. We will be breaking it up into the pertinent rules, the charter parties, the history of and practice of carriage of goods by sea. Carriage of goods by sea is one of the central topics in international commercial law, especially in the area of international sales of goods, or others will say international business transactions. The reason why it is central to international business transactions and international sale of goods is that the typical international business transaction contract will address the issue of transportation of the goods. And the issue of transportation of the goods will require us to pay attention to the clauses referring to transportation of goods, either in the form of packages stored on containers, or it will require talking about the charter of the entire ship to carry the goods that may exist in very large quantities, and therefore a charterer needs to be the one involved in the contract with the ship owner. Thus, our concern today will be to break down this area of practice, area of law, area of contract into a number of slides, in which case we have about 90 here, which shows that it's a massive topic. It's broken down into different sections, and it's one which we as students of this module should pay close attention to. We have a lot to cover. We, as I said, will cover the history of international sale of, history of maritime practice. We will cover the contract of the carriage of goods by sea, which also will necessitate a look into the rules, the international conventions and rules by which this area of law is governed internationally. And of course, as I said, we'll look at charter parties, which is the charter of an entire ship by the charterer from the ship owner, and referring to those massive quantities that can only be covered and governed by the law around charter parties. What else will we be doing? Quite a lot, hence we'll start from the beginning, which is to look at the history of international carriage of goods by sea. And it's suffice to say that the carriage of goods by sea is one of the oldest forms of transportation of goods in human trade history. We will, while we're going on in this section of the class, show a lot of the statistics that proves the centrality of maritime transportation to mankind, but it is also important for us to look into the deep history of the maritime transportation practice. And this will take us down into antiquity. It will take us down, perhaps, to the beginnings of international trade between peoples, even before the existence of civilized states as we know it today. Mankind has been trading with far-flung territories and the easiest way to move loads of goods, heavy equipment, and plenty of people around between two places would be by carriage of goods over maritime territories. Hence, the history of the content of trade in international affairs has also been the history of the transportation of goods through maritime territories, whether we're talking about slaves, or we're talking about copper, we're talking about iron, we're talking about any commodity, or we're just talking about large numbers of people. The best way to transport them between two states, two territories, two continents is by sea. And therefore, it's also possible to trace the very beginnings of legislation in this area to many of the old maritime collection of laws that are known to us today, such as the rules of Oleron, the laws of Visby, the Consolato de Mar, the Republic of Amalfi also collected its maritime laws. And from these old practices, dating far beyond and before the medieval period, dating into antiquity, as I said, you will find that mankind has been conducting maritime transportation and has even been reducing the rules, the duties, the liabilities into written collections, which maritime practitioners followed over the centuries. We also note that it has not been a linear progress where everyone behaved themselves and adopted the best of behavior in maritime transportation. It would be a surprise if that has been the history, because that certainly has not been the history of other areas of mankind's interactions. So what am I saying? I am saying that there were testy periods in the carriage of goods by sea. And in a sense, one might even say up to now, we still have testy periods. There was a period when piracy troubled maritime transportation. There was a period when states funded the disruption of maritime transportation fortunes of other states, as found in one of the pages, page 419 to 420 of Braithwaite and Drahaus Global Business Regulation, a book I have here, one of my most respected works in this area of international commercial law that I like referring to. Braithwaite and Drahaus draw out for us a period in history when the Dutch preyed on the English, the French preyed on the Spanish, the English preyed on the French, the Barbary states said to have preyed on everyone else. In short, the major powers allowed piracy to flourish because it was militarily and economically useful. In short, carriage of goods by sea has always been an area fraught with dangers. And even as we speak today, there are parts of the world where piracy is rife. It's rife in the Gulf of Aden. It's rife in the Gulf of Guinea. Piracy continues to blot the maritime practice, just as much as other areas of international relations continue to make maritime transportation difficult, such as sanctions, such as blockades, such as various acts of aggression between states, and so on and so forth. So it's not been a linear progress of commendable development. But at any rate, it's quite important to spend some time simply appreciating the awesomeness of the carriage of goods by sea as an activity, as an international activity. Carrying goods, sending goods from one territory to the other in trade is simply the blood of world trade. Seafarers are, in effect, the lubricant without which the engine of trade will simply grind to a halt. And we have proof of that in statistics. 95% of international transport of goods by today is done by sea. The volume of goods transported through the seas and maritime zones is impressive. It's simply mind-boggling. The volume of trade that passes through some of our nearest ports here in England alone, like Dover, Southampton, etc., are simply, as I said, impressive. Many of the major ports in the world continue to efficiently process contracts of transportation in terms of the millions of tons of goods that cross, that go through those ports on a daily basis. And some of the things we would see later on in the lecture would include the fact that developed states have a lot of advantages in the law and practice of carriage of goods by sea. We would see evidence of that. But what is also beginning to be clear is that developing states are also beginning to literally take over maritime transportation. They do so in so many ways, some substantive, some less consequential, but the trend of travel in maritime transportation, in maritime contracts, is going in the favor of developing states. Statistics is establishing that. A lot of the registration of ships is now taking place in developing states. A lot of maritime traffic is going towards developing states and from developing states. More particularly those states that are becoming more successful internationally in their economy as developing nations, the BRIC nations, the transition economies. They are doing a lot of business in maritime trade, which is stealing out of the previous dominance that maritime powers like Britain used to have. Britain, Portugal, and the whole world, as you may want to look at it if you want to use that for the old colonial states. So statistics shows that a lot of seaborne trade is increasing, that a lot is happening in maritime transportation, and that developing states are becoming more important in the estimation of global carriage of goods by sea. Along with that, of course, is the problems that you will see that any intense use of global spaces will produce. Just as intense use of aerial territory for transportation produces a lot of and contributes to global warming, when our planes fly incessantly, every minute of the day, plane is landing, taking off somewhere in thousands, if not hundreds of thousands, certainly in the course of a year. Similarly, in maritime trade, or we should say particularly more in maritime trade, because of the intensity of maritime transportation, one clear way in which another negative side of things can be discussed is pollution of the seas. We wouldn't stay on that topic for long, but it suffices to say that pollution is increasing. The causes of pollution in maritime transportation include groundings, equipment failures, hull failures, fires, explosions, deliberate and indeliberate, inadvertent actions of sabotage, of malpractice. Whatever it is, pollution is increasing and should be of interest to us as well. But it boils down to the fact that more and more states are involved in maritime transportation. More and more states are represented in the success of carriage of goods by sea. There will be positive and there will be negative sides to the story. Again, just for emphasis, I repeat that the success of developing states is becoming apparent both in ownership of vessels and in registration of vessels, and with I suppose I should say, there is a curious little term that needs explanation. It's called the flag of convenience. You might have heard of it, but the flag of convenience simply refers to the practice whereby ship owners look for certain jurisdictions to register their ship in, because all ships must carry nationality and all ships must be registered on the records of a particular country. Yeah, so under the flag of convenience practice, owners of ships across the world look for certain states to do their registration, to register there only as a convenient way of escaping the heavy compliance that their own state would require if the ship or vessel is registered at home. So there are some states that make their jurisdiction open to anyone to come and register their ships there for a small fee, but because of the volume of registrants, they make a profit from that. International law only requires that you must be registered. It does not prescribe where you're going to be registered. So for those states that have sort of placed themselves in an advertised position to receive registration, they make a profit from that. It's a practice that is criticized, highly criticized by lawyers, by statesmen, but it's something which continues, and I don't see the end coming to that practice soon. And the flag of convenience states would include small states like the Marshall Islands, or Liberia in Africa, Singapore, Malta, China, states that deliberately posture themselves to attract that kind of custom. So, as I said, the statistics is just impressive. Maritime transportation in terms of gross tonnage is mind-boggling, and the statistics is something that should be of interest to us as students of the law. Having said that, it remains to just talk about the contractual papers and the law that relates to the practice of maritime transportation. And in that sense, I move to introduce to you the contractual issues in the carriage of goods by sea, law and practice. I would introduce the regular terms. You can't have it all, but you will have enough to have an informed postgraduate view on this topic. And it will indicate the issues that tend to end up for dispute resolution in arbitrations, in lawsuits, the papers that are key to maritime transportation. Contracts are best written on papers, are best recorded in permanent form. That's what I should perhaps say. And when that recording of the contractual obligations in permanent form has been done, the issues that tend to be significant, the points in the contract, the trigger points in disputes, are some of the things we will be mentioning and dealing with now. Needless to mention that when we talk about contracts, we nowadays also include electronic contracts and electronic contract documents. So what is a contract of carriage by sea? It's a crucial contract of affreightment. Contract of affreightment, the technical term used for the carriage of goods by sea contract. And as I hinted earlier, it includes both the charter party, which is the transportation of bulk goods chartered by a party, and the second form, which is also very important. In fact, that's the area where most of the contracts tend to happen, is transportation via individual packages in containers. And that contract tends to be done under the bill of lading, law and practice. So those are the two types. Perhaps a diagram will make it more easy to follow. So the contract of affreightment generally happens in two forms. There are two types. Contracts evidenced by bills of lading, which in terms of numbers is the vast majority, because people rarely send things in such bulk that they need a whole ship for it. So transporting goods between two territories tends to be done by bills of lading. Packages, entire containers, several containers, requiring one bill of lading to evidence the contract. That's one way of carriage of goods by sea contract. The other one is the charter party, where bulk necessitates the use of the maximum space on a particular ship, and therefore the entire ship is chartered for the purpose. The bill of lading, let's start with that. Bill of lading transportation has occurred over the centuries, has a custom, has the lex mercatoria behind it. And by lex mercatoria, we mean the law of merchants. The development of the document known as the Bill of Lading relies on a rich history of maritime practice, which is part and parcel of the lex mercatoria, the law of merchants, which dates back to the medieval times and continues today under the new lex mercatoria. So over time, in previous centuries, as early or late as you may want to put it, depends on how you're viewing it, as 1885, the UK had its Bill of Lading Act, which solidifies the practice, the custom of the use of bills of lading. A bill of lading, I think there's been a topic on that in this module so far. But for our purposes, we just need to remember a few things. That it is a receipt. It is also an evidence of title. The bill of lading is a transferable instrument. It is a negotiable instrument. It can be transferred again and again and again, and it is evidence of title. The bill of lading has now been the ideas, the law, the practice, the provisions of the Bill of Lading Act have now been incorporated into the Carriage of Goods by Sea Act 1992. The Carriage of Goods by Sea Act is a national law of the UK, but it domesticates the international obligations of the UK under the Hague Visby rules, which we'll be coming to shortly. The holder of a bill of lading is entitled to the goods. The holder of a bill of lading has a very important document in his hands, which is evidence of ownership. Let's identify a few of the dramatis personae, the practitioners in this area of academic discourse. The ship owner would sometimes be referred to as the carrier. The shipper would be referred to as the exporter. The forwarder is a person who is retained for business by the shipper, who is the person who wants to send things out to another territory to procure the space on the ship for him or her. So those who are engaged in international sale of goods need to satisfy the transportation element of moving the goods from them as sellers to a buyer. Since they do not own ships, they also do not have time to follow the arrival of ships and where ships are available, what size of ships is coming, does it have refrigeration, can it carry gas? All that is left to the specialized professional known as the forwarder. The forwarder is a person retained for his knowledge, his expertise by shippers to find boats for them and find space for them and arrange the transportation of the goods, in many cases, onto the ship and forwarded, of course, to the other territory. Just as the seller is unable to know the movement of ships and who is bringing a ship that is suitable on good time for him, so also the owners of ships are unable to tell precisely who in the whole wide world, at least in the places that that ship is going to, needs the service of shipment. So ship owners also retain a professional to do that business for them. And that professional is known as the broker. So the broker is the person retained by a ship owner to obtain cargoes for his ship. Enough about the dramatis personae. Now let's talk about the specialized papers that are needed in this area. One of the initial specialized papers that you need to know about is the sailing card. The sailing card is a printed notice which contains reference to when a ship is available, where it is available at, the date that the ship will be at the port, the date that the ship will start accepting goods, the date that the ship will stop accepting goods, the date that the ship will sail. These are all, and then from there on, which port will it stop, or which port is it going to directly? All this kind of information is very useful, very necessary, of technical and legal value to shippers. Hence, you will find a few slides on sample sailing cards. The typical sailing card will address the name of the ship, will identify the ship, will identify the date it's going to arrive, will identify whether it is willing to start accepting goods, will identify what type of goods the ship is able to pick, and when it will close doors, when it will sail, where it is going to sail to, and so on and so forth. So the sailing card is a technical card. It's a technical document that is quite useful to those who need to transport goods by sea. Then we have specialized papers of proof of shipment and conditions of arrival of the goods on the boat. The first one that you need to know about is the mate's receipt. The mate is an official on board. There are several mates actually, but there will be one who is perhaps the head or the one who is charged with the task of issuing out a receipt for the goods that arrive on board. So the mate's receipt is an initial document filled by the ship's mate, and the official on the ship, the official that works for the ship owner, which identifies which goods are produced on board, the date of the loading, identification marks, how many packages, in what condition do they arrive, are they soiled, are they wet, are they damaged, are the cars chipped, whatever it is, the paint around the car, is it in good order, whatever it is that helps to solidify and give us certainty as to the condition of the goods when they arrive and the condition of the goods when they should be handed over. All this type of information is filled onto the mate's receipt. And the tally clerk will put this record based on his visual observation, sometimes requiring the use of testing equipment, testing instrumentation, whatever it is. There are so many kinds of trade out there, so many kinds of reasons for transporting so many specialized type of vessels that we don't have time to go into all of them. But all I can say is that the mate's receipt is very important, because if the mate's receipt is qualified, which means it's certain clauses in it show that the goods are not arriving in perfect order, or they did not arrive in the numbers that they should, then such a claused mate's receipt will be seen as unclean. It's not useless, but what it means is that every single detail on the mate's receipt is going to be transplanted and also placed into the very important document which we know as the bill of lading. So when a mate's receipt is clean, the bill of lading will show that a clean mate's receipt was received. If it is claused, that will also be transferred onto the bill of lading. All these have legal implications in terms of who damaged the goods, what conditions the goods ought to be in when it is handed over to the person who produces the bill of lading. So the bill of lading is the document that comes after the mate's receipt. The mate's receipt is not a negotiable instrument. It is not an evidence of title. It is only a receipt of the condition of the goods and the type of goods. Information that is still needs to be put onto the bill of lading has to be put on the bill of lading, but that information will be advised by the mate's receipt's contents. Now we can talk of the bill of lading. We're not going to talk too much about that because we've had I understand there's been a full class on the bill of lading. So the bill of lading is an original document issued in triplicates usually. Some will say up to 6 different copies of the bill of lading may be issued. Each copy of the bill of lading is an original document. The reason why the bill of lading is issued out in multiple copies, each of which is original, is because an attempt is made to send them on different dates by postage to the buyer to make sure that at least one of those copies gets into the hands of the buyer. We need to understand why this may be necessary. We're talking about maritime transportation here. We're talking about maritime transportation practice, which has been going on for centuries. So when you send things by ship, they don't arrive the same day. They arrive sometimes weeks later, sometimes months later. It's not unusual that it may even take up to a year, particularly in the past. But the more important thing is that the letter, the bill of lading, will certainly arrive before the goods. And it is fortuitous whether if you post something, it will get there. But if you post 3 copies of it on different days, then you increase the chances of it getting into the hands of the buyer. Once it gets into the hands of the buyer, he has at least a copy to present to the ship owner when the ships arrive. And that copy will be an original copy. Any copy he presents will be the original copy, and others get cancelled from that moment on. The reason why they are cancelled is simply because there's no goods to collect again. One valid copy has done the collection, and the shipment has been handled properly. So the duty, however, is on the shipper to make sure, on the ship owner, the duties on the ship owner to ensure that the goods are handed over only upon a production of a valid bill of lading to a bona fide possessor. For some reason, we're going backwards, but we'll trace our way forward, hopefully, as time goes on. Yeah. So the bill of lading, again, is a specialized instrument, a specialized paper. It will show the type of goods that are put on board. It will show the number of the goods. It will show the condition in which they arrive. As I said, many of the facts on the face of the sailing card will be, sorry, not the sailing card, sorry, certainly not the sailing card. Many of the facts on the mate's receipt will be transferred onto this the bill of lading. So it's a specialized paper, and it does every of the wonderful things that I've said so far, evidence of title, and so on and so forth. But it needs to be said that the bill of lading is something which the ship owner must make sure he asks for, and he collects evidence of. Because if anything goes wrong and he hands over the goods to someone who is not supposed to be the owner of the goods, that did not produce the bill of lading, then the ship owner takes responsibility in law and in fact. He therefore needs to compensate compensate the owner of the goods for handing over the goods to the wrong person. That is definitely one of the key areas of disputes, key areas of wrongness that takes place in maritime transportation. If the goods are lost, then freight will not be paid. Freight is the remuneration of the ship owner for the service of sending the goods. Freight is only payable upon safe carriage and delivery. If the goods are lost, then the ship owner needs to compensate. Makes perfect logic. However, note also that insurance is one of the key sub-issues and the sub-areas of practice on this topic. So obviously the ship owner will also rely on some solid insurance, and in many cases the shipper also would have taken insurance. So it might be a case of insurance companies paying up and then following each other where applicable. The tender of a bill of lading is an important fact. It's a receipt of the documents of the goods, and it also reflects on who, it shows who and when the duty of collecting insurance payments lies if something goes wrong. Let's move on from the specialist papers and identifying the individuals and parties that usually occur in maritime transportation, carriage of goods by sea, and move to the international legislative history of the contract of carriage by bill of lading. In other words, maritime transportation, maritime carriage of goods needs certain, and it would be a surprise if it was not so, shipping is necessarily international, needs certain international rules that dictate actions in relation to this area. And those rules are, over the years, shown to be many. They started off by being one set of rules by states that agreed to formalize international carriage of goods by sea rules, the laws, the rules, the obligations, the duties of the shipper and the buyer and the seller and the ship owners. All that was agreed to by states at a point in time. But as with many areas of commercial law, international commercial law, dissatisfaction occurs. And as a result, newer rules are near constantly being drawn up to take care of business. I must again tell you that it's a principle of international commercial law that states even parties, businesses, are not obliged to leave one set of rules for the other, and they are not obliged to do that at any particular time. So the fact that a new set of rules exists does not mean that the old set of rules are inapplicable. For as many states and parties and people who are still obeying the last rule and still find themselves under its jurisdiction by not using any other one or by sticking to the one they know, it remains a valid choice for them. Why do I say that? It's because I'm about to start describing the development of the rules and why we now have a disunity in the practice of the rules that govern contract of carriage of goods by sea by the bill of lading method. We have a fragmentation of rules, and they include the Hague rules, which is the first one, followed by the Hague-Visby rules, followed by the Hamburg rules, and the last rules, international rules, is the Rotterdam rule. Let's start with the Hague rules. The Hague rules was the first formulation. It tried to reflect international public opinion, international public practice in the area of unification of the use of the bill of lading, so that it's not just dependent on the lex mercatoria, not dependent on various acts of various countries, but let's sort it out and have a set of unified rules. That's what the plan was. Because it's a negotiated contract in the form of a negotiated convention, the politics among states ensured that the powerful states in maritime transportation had their way and their say. And what that meant is that several defenses and limitations were introduced into the Hague rules to protect the ship-owning class. The ship-owning class and the countries where those ship-owning owners come from ensured that the unification of certain rules, convention, the Hague rules, protected their interest. And what that meant was that a lot of scope was left for too much of scope, I should say, was left for the use of exemptions to the use of liability. So the owners of the ships, the ship-owning class, made sure that they could exempt themselves from a lot, including even their own errors, even their own negligence, even their own mistakes. And of course, that is unacceptable to the vast majority of shippers, which meant that dissatisfaction by 1968 led to some states, again, coming together to try to arrange a new legislation, international legislation convention, known as a sort of amendment to the Hague rules, now called the Hague-Visby rules, signed in Brussels. The idea was to replace the Hague rules with a more user-friendly instrument, which does not allow shippers to constantly relieve themselves of their very obligations in contracts of carriage of goods by bill of lading. Some progress was made under those changes, yet it was unsatisfactory. Unsatisfactory definitely from the perspective of the developing states, where a lot of the shippers are resident in, sending goods to the center. And by the center, I mean richer countries, maybe commodities, whatever it is that people are buying and selling amongst each other. So what the states from the developing world then tried to do was to champion a new rules that is designed by the United Nations and therefore enjoys the participation of more states using the democratic method of decision making. So they came up with the Hamburg Rules of 1978, which was meant to take care of the developing world's problems, the interests, and complaints. And the hope was that more states will come under the Hamburg Rules, and the Hamburg Rules will now be the latest one and would solve the problem of too wide exemptions and defenses that the ship owning class had when things go wrong. I'm sorry to say, very disappointingly, the Hamburg Rules did not attract enough states to sign up to it. And as a result, I think about only 15 states signed up to the Hamburg Rules. So it was not a success either. But it had some states that had moved on to it. Clearly, it should be coming clear to you, if I can describe it that way, it should be becoming clear to you that we now have 3 rules. States finding themselves in the 3, making it very confusing which of the rules to adopt or which rule of the rules has been adopted by the participants in carriage of goods by sea, creating a lot of confusion in the decision of cases across the world in courts. So the original unity that belonged to the Hague rules was lost, partially when the Hague-Visby amendment took place, was lost further when we have the Hamburg rules. We now had 3 separate rules. And what did we find afterwards? We found out that states demanded for even more, a new rule that is supposed to cure everything. Hence, the Rotterdam rules. The Rotterdam rules were brought into existence under the UN Convention for the International Carriage of Goods, wholly or partially, by the sea in 2009. The Rotterdam rules was meant to merge the interests of states, to bridge the system, to incorporate the best parts of the Hague-Visby, the Hamburg rules, and to be more satisfactory, and to certainly give more liability against ship owners who do not diligently run their shipping operations. So therefore, it had less liability. It had more liability in favor of shippers, those who are putting goods on fire. It removed the defenses of error in navigation that availed ship owners in the past. It removed the defense that allowed them to exempt themselves from management errors, fires on board, and so on and so forth. It strengthened the need for the vessel owner to put only vessels that are seaworthy on the seas. I regret to announce that the Rotterdam rules are not yet in force because it has not gotten 20 ratifications yet. All we have now is an increase in the disunity of the original unity that exists under the Hague rules. We now have 4 major rules and more confusion. But these are the 4 major rules that lawyers still need to operate under. So they need to decipher which of the rules are being used by the parties. Hopefully they identify it. The facts may lead to it as well, based on the territories where the contracts were signed and so on and so forth. that's the exciting place we are with the international legislative history. But a few points need to be made about how these treaties work when they have been used. When any of the treaties have been identified in a shipping contract, the practice of courts has been to give interpretation to the contract that incorporates them, that tallies with international law, that tallies with international obligations. So shipping is an international affair. And when any of the rules have been identified, courts will ensure that they are given the best interpretation which other courts have been given across the globe in relation to the meanings of the obligations. Hence, Lord Denning commented in Stagline and Foscola that even if I disagreed, I would follow the decision of other courts in a matter which is of international concern. The courts of all countries should interpret the Warsaw Convention in the same way. So it's not to be, we shouldn't be surprised that states do their best to follow the law to interpret the law in a way that is less national, but actually more international. I'm having some problems with, but so we'll be back. Just give me a few seconds. I think this is a nice opportunity to move to the issue of the ways by which the duties or the rules determining the duties and liabilities of those who engage in carriage of goods by sea, particularly the carrier and the shipper. The carrier is a person who includes, is a person who owns the ship. The carrier includes the owner or the charterer who enters into a contract of carriage with a shipper. The shipper, on the other hand, is the person who placed goods on the ship. The rules as to their rights and liabilities is identified on the contracts that they have signed, the specialized paper, the bill of lading. It is also evidenced by the rules they have adopted. So let's say, for instance, we take the case of UK, which is under the Hague-Visby rules. The Hague-Visby rules have sections that deal with the rights and duties and liabilities. The bill of lading would also support that. But the more important thing to note is that the rules are such that allow us to be a bit certain about who is to be held liable when certain typical things go wrong. When the goods are lost, when the goods are damaged, the issue of whether the ship was seaworthy in the first place comes up. So seaworthiness is an obligation that is placed on the owner of the ship. You must ensure as a carrier that your ship is worthy of the adventure of maritime transportation. has to be a ship that is durable, that is robust, and can handle the normal perils of the sea. So Article 3, subparagraph 1 of the Hague-Visby rule says that the carrier shall be bound before and at the beginning of the voyage to exercise due diligence to make the ship seaworthy. What that means is expanded upon in various decisions by courts, and I've given quite a number of cases in the PowerPoint to help out with this. It includes that seaworthiness expects us to demand of the owner of the ship that due diligence has been put into maintaining the ship in good order. What that means is that carelessness, negligence will go to the roots of your seaworthiness liability. If, as in the case of Maxine Footwear, an officer on board uses a blowtorch to try to thaw a frozen pipe, then obviously the seaworthiness of the ship has been brought into question. Seaworthiness is actually a wide category that takes in a number of things which might not at first be apparent deal with seaworthiness. So, for instance, cargo worthiness, whether the ship can carry the precise cargo, whether the ship can carry the precise cargo safely, whether the ship was the cargo was stored in the right way on the ship, are all aspects of seaworthiness, unless there is an exception, such as in the bizarre case in Albacora and West Coast, where the fish spoiled, not due to any fault, but because of an unusual bacterial action, the fish stored on board. That's an exception. But if it can be shown that the cargo worthiness of the space where things are stored was not okay, was not proper, then therefore the cargo, the seaworthiness is also called into question. Cargo worthiness is an aspect of seaworthiness. Another surprising thing might be that not having the right papers, not having the right shipping papers, or giving the right shipping papers is also an aspect of cargo worthiness. There are other duties to talk about. Let's talk about the duty to pursue the voyage in a direct manner. That's a duty under the Hague-Visby rules. So the Hague-Visby rule says that carriers, that ship owners, ship operators must proceed on the contract voyage expeditiously, reasonably, and competently. Deviation is not allowed. You don't carry people's goods away from the route that has been determined. Don't forget, I mentioned about the sailing card much earlier. So the sailing card tells us where the ship is going. It might be going just between 2 points, or it might be going to 4 different ports, for instance. If we find out that the ship now moved in a way that does not go to those identified ports, that will be a deviation. And deviation is quite fatal to maritime transportation because it exposes the goods to danger. It exposes the goods to the possibility of more time. Time is of essence in business. Time is of essence with exports, and it might have contributed to the loss. So deviation is a strong, vitiating factor in maritime transportation contracts. Unless the deviation can be placed under some certain headings of exceptions, such as that the deviation was to save life or to save property, like another ship or the ship that is carrying the goods itself. if there's a way to prove that there was reasonable deviation, that might prove important. So any deviation made to save life or property at sea might be an exception, but the facts will tell us whether that really was the case. And the facts is always interesting in this area. So you have a duty as a carrier to pursue the contract voyage expeditiously and quickly. Another duty, we'll come back to talking about duties in charter parties as well. So we might as well just move on to the last part of the class, the last part of this lecture, which is where we talk about the voyage charter parties. Again, under the treatment of the voyage charter parties, you will see references again to duties and implied terms, which some of which will repeat what we dealt with, or which you will read. And I do hope you get to read the full PowerPoints and then move on to read the textbooks in this area, because naturally, a 1 hour, 1.5 hour lecture with PowerPoints is not enough. A lot of independent reading will be necessary in this very exciting, very interesting, very rewarding area of law. Voyage charter parties. Voyage charter parties are, or charter parties, are the specialized contracts between a shipper and a ship owner in relation to the contract of carriage by goods by sea, carriage of goods by sea, where the entire ship is contracted upon. The entire ship is owned, not owned, certainly not owned, is now under the control and use of the charterer. As I said, this is used for bulk shipping, and there are roughly 2 types of charter parties, even though in practice people identify more subcategories. The first one is the voyage charter party, and the next one is the time charter party. Each one of them might hide other categories, but we'll stick with the 2 broad categories for now. The voyage charter party is where the ship owners agrees to let his ship work for the charterer for a voyage or 2 voyages. This entire voyage is what is contracted for, or the entire 2 or 3 voyages is what is contracted for. Move from here to there is a voyage. Move from here to there and back, we're seen as 2 voyages. So the voyage is what is contracted for, and the entire ship is what is contracted for. Under this kind of voyage charter party, the vessel naturally still remains under the control of the owner of the ship, because the voyage is identifiable, the time with which it will take place is easily identifiable as well. Therefore, the ship owner maintains control, is responsible for equipment, is responsible for manning of the ship, determining the speed at which the ship will travel, is responsible for paying the staff, and so on and so forth. The charterer simply wants his goods to be able to move, and his goods only, his bulk, only the bulk on board. On the other hand, the time charterer charters the ship for periods, for identifiable periods on the calendar. It could be for a number of years, it could be for a few months. It depends on what has been inserted on the face of the contract or what they've agreed to. The ship owner, in this case, may continue to have control of the ship because it's for the time, but the time may be so long that if the time that the ship is going to be under the control of the time charterer is too long, it might affect the level of control that the time charterer, the time charter owner of the ship will exercise. But under a time charter, the specific voyage does not need to be identified. It's not necessarily agreed upon. What is agreed upon is that the ship will be returned to the ownership. The ownership remains with the owner all the time, but the ship will be returned to the possession of the owner of the ship after the specific time. The crucial provisions that the time charter will probably turn on, where they will have to agree on, will include the speed at which the vessel will be flogged around, who is maintaining, how much are we paying, when exactly is the ship coming back. These are things that need to be agreed upon in a time charter. And then there's the curious demise charterparty. The ship owner here completely relinquishes possession and control of the ship for a period of time. So it's a form of time charter, but what makes it a demise charter is that the ship owner has agreed to not be in charge of anything. It's just, here is a bare boat, have the boat, have my ship, bring it back at the end of the period. You as the demise charterer are in charge of fueling, you're in charge of the captain, you can bring your captain on board, you are in charge of employing the cooks, you're in charge of even maintenance. However, bring the boats back at the end of the period of of the charter. Might even include that the charterer is responsible for insurance. What needs to be talked about now is perhaps to remind us that charter party, just like the bill of lading, transportation, is well steeped in practice, steeped in a long history of practice. And to that extent, I have supplied here some sample charter party contracts, such as the GENCO, which is the standard charter party used by BIMCO in its work. You can click on those on the links and find out about these organizations, what they do, the important work they do. But what you need to understand is that depending on the area of maritime practice and transportation, you will have a settled body of practitioners, and you will have their forms that you can rely on and adopt, especially when you are chartering in that activity. So this is a sample from the North American Grain Charter Party way back, used since the 1973. So it's this kind of standard contract specimens enjoy the benefit of years of practice, decades of practice, and therefore, if they are retained and still used by the professional body, it's always a sign that it is safe to use and adopt those forms. The important thing to us to do now is to remind ourselves of the rights, duties, and liabilities again. Under the charter party, there are implied terms. The implied terms work in two ways. There are implied terms on part of the ship owner, and then there are implied terms on part of the charterer. These are just doing nearly the same thing that we saw in the Hague Visby rules, doing what the Rotterdam rules is trying to do, set of laws, set of rules that everybody understands, governs the rules and liabilities, sort of things done by the Hague rules. That's done for and used for bill of lading transportation. For charter parties, the implied terms tries to do the same thing, but it's more steeped in case law, more steeped in practice, more steeped in international lex mercatoria. They are similar, and they include the duties on the ship owner is to provide a seaworthy ship. We've had that before. To proceed with due dispatch. We've had that before. Don't deviate. To carry goods without deviation between two destinations. To exercise due care and skill. And the duty to deliver the goods to identifiable person and at the right port. Don't carry people's thousands of tons of oil to the wrong city or discharge them into the pipes of the wrong company at a port. These are implied terms under the charter party law and practice. What else do we want a careful ship owner to do? We want him to understand that the standard of liability is one which is strong. It expects the ship owner to be able to put on the waters only a ship that is fit to encounter the ordinary perils of the sea. Only a ship that is seaworthy. Seaworthiness again includes cargoworthiness. Seaworthiness again includes documentation. Seaworthiness includes the duty to employ only reasonable people, professionals, and not idiots to operate the ship. Case law, varying case law have been provided for you in this PowerPoint. Please see them. Seaworthiness, again, might include things like not putting enough crew, not employing enough crew, and so on and so forth. When does the obligation of seaworthiness arise? It arises immediately the ship begins to receive goods. It arises when the ship is receiving goods. It arises when the ship is in motion. It arises when the ship has stopped on the other hand. It arises until the goods are discharged from the ship. There is no point at which the ship owner is allowed to rely on his own carelessness or on his own unseaworthy vehicle just because it goes, for instance, just because the ship is not sailing right now. So there's a doctrine of stages which makes it an imperative that the ship must be seaworthy at every stage of the voyage, everywhere it stops, and while it is stopped, while it is packed. Hence, when goods are arriving on board and the ship is not even going to sail until about 5 days' time, but it has started receiving goods, if the ship catches fire as a result of not being a seaworthy ship, then the ship is not seaworthy. Deviation, many cases to go through. The effects of a breach is that the goods, the contract may be suspended. It's also that if there's a breach, such as deviation, the ship owner becomes a wrongful bailee. What do we mean by a wrongful bailee? Someone who is wrongfully in possession. You become wrongfully in possession from the moment you start doing things that are not on the contract, or that by the implications, the implied terms, you are now wrong. You are doing things outside the contract. That's not a good place for a ship owner to find himself or herself. On the charterer's part, it's not just the ship owner that has duties. The charterer has duties. There's a duty to nominate a safe port. So when you charter people's ship, taking oil from one continent to the other, whatever the distance may be, you have to ensure that the port where it is going is a safe port. If the port becomes unsafe during the journey, it's your duty to inform the ship that it should not proceed on that direction again. So nominating a safe port is an implied term on the charterer, and the meaning of a safe port is quite varied. It includes places where the politics has changed and made it unsafe. It includes places where wars have broken out. It includes places where strikes are on. Whatever it is that makes it unsafe for the ship. Hence, in the case the Eastern City, the decision was made that a port will not be safe unless in the relevant period, the particular ship can reach the port, use the port, and return from the port without being exposed to danger. That's the definition of a safe port. On the part of the charterer, the duty also exists that the charterer must not do anything that makes the ship carry unsafe goods. So don't charter people's vessels in order to carry dangerous or illegal goods. So if you have chartered a ship to carry rice, don't then store on board explosives. Don't store on board illegalities. This will all go to the implied terms on the charterer, and there's liability for not following those the rules. There are exceptions to both the implied terms of the charterer and the implied terms with respect to the ship owner. They include acts of God when something inexplicable happened, despite your not being the cause of it. See Nugent and Smith. When the king's enemies, now king's enemy, when the king's enemies suddenly swing into action to destroy the ship or to impede the ship, leading it to deviate, these are exceptions to the duty. Inherent vice. An inherent vice includes the one I gave in earlier, an example of earlier on the Albacora and Westcott, where inexplicable. Nobody knows how this happened. This is not the fault of any particular person. A freak incident, an unusual development of bacterial action, for instance, especially as in the Albacora case. Yes, that could be an exception. Jettison, when due to maritime practice of safety, the load on the ship needs to be reduced, and things need to be thrown aboard to stabilize the ship. That's an exception that, for instance, the charterer, the ship owner can rely on. Perils of the sea. Technical, difficult to explain, but if you can prove that an unusual perils of the sea, a freak wave that no one has seen in recent times or has seen before, some monster of the sea is at action. If you succeed at that, then it might be a contractual exception. Strikes and lockouts might be a reason why there is an action. And then there's the use of the Caspiana clause, which allows you and gives you permission ahead to discharge at any other safe or convenient port. Fire exceptions, issues of insurance also need to be looked at. With all this, I do hope I have introduced you to carriage of goods by sea, law and practice. Thank you very much for listening. Good day.